Hi, welcome to Law for All, where we try to make the law more comprehensible for everyone. I'm Brent Cooper, a partner at the law firm of McLeod Law in Calgary, Alberta. I've been a lawyer for more than 30 years. I'm a litigator, trial lawyer, business litigator, and collaborative practitioner. Today, we're going to be reviewing iconic legal scenes from movies or television shows. The Social Network, Questioning Discoveries.
In late November, I got the email from Mark telling me to come out for the millionth member party.
What else did the email say?
It said that we had to have a business meeting, that Mark and Sean had played some kind of revenge stunt on Case Equity, and that Manningham was so impressed that he was now making an investment offer that was hard to turn down.
It's interesting. It's not just a questioning. There seems to be some kind of contested hearing going on in a boardroom. It's possible it's an arbitration. We'll see a little bit more, but I can see that one party is testifying and another party, obviously the opposing party, it seems, is sitting there and watching.
Straight to the new offices. I didn't know whether to dress for the party or for the business meeting, so I kind of dressed for both.
I guess the other thing that occurs to me so far in this testimony is that the witness is going on at some length without prompting from the lawyer. That's a little bit unusual, unless there's been a lot of rehearsal between the lawyer and the witness. You wouldn't quite expect such a long-winded narrative.
But it didn't matter.
Why not?
There you
Because
are,
I wasn't
the lawyer
called out
says
there for
something.
either one.
What were you called out there for?
An ambush.
What's interesting there is the lawyer has prompted the witness to characterize the nature of the meeting that he is testifying about. And he calls it an ambush. Now, that was rehearsed. And I'm not surprised at that. It's absolutely plausible that a lawyer and a witness would have rehearsed that, as long as the lawyer is certain that that is the witness's sense of what happened. But it's powerful testimony because the witness is actually characterizing the nature of something as opposed to just talking about what happened. And a judge would normally want to reserve for himself or herself whether indeed the meeting was an ambush. Legally Blonde, rebuttal witness. So I'm told this is an iconic scene from Legally Blonde. I'm sort of ashamed to admit a movie I've never seen. I know quite a lot about it. I've heard a lot about it. I think there's even a Broadway musical called Legally Blonde. And apparently this is a scene regarding the calling of a rebuttal witness. Because I'm seeing this for the first time, we'll find out whether the lawyer is questioning her own witness or cross-examining the other side's rebuttal witness. Let's find out.
Miss Wyndham, what had you done earlier that day?
I got up, got a latte, went to the gym, got a perm, and came home.
Well, you got in the shower?
Okay, so it's pretty clear to me that this is a cross-examination by the lawyer. She's holding a transcript. I think she's holding a transcript. It's apparent that she has heard this rebuttal evidence for the first time and possibly did not even have a prior transcript of what this witness has said, maybe hearing this for the first time. And you can tell even by the apparent spontaneity of the question that has just been asked that she is literally winging it as she goes. Very, very, very challenging for a lawyer to do in a courtroom.
I believe the witness has made it clear that she was in the shower.
Yes, Your Honor. Miss Wyndham, had you ever gotten a perm before?
Yes?
The judge has made a joke at the lawyer's expense, and lay people, non-lawyers, may wonder whether that ever happens. The answer is it does. Maybe not quite as dramatically as you see in movies and television shows, but there are times when as long as it's fair, literally fair, based on the evidence, that a judge may have a little bit of a dig at counsel, just to have a little bit of entertainment.
Had you ever gotten a perm before?
Yes.
How many would you say?
2 a year since I was 12. You do the math.
You know, a girl in my sorority, Tracy Marcinko, got a perm once. We all tried to talk her out of it. Curls weren't a good look for her. She didn't have your bone structure.
The lawyer doing the cross-examination literally just turned to the jury and said something about her own life, or said something apparently general about the nature of women and so on and so forth. I know that in the United States, there is more latitude used by counsel in jury trials. Jury trials are a little less common in Canada, but the proposition of a judge allowing a lawyer to just make a statement like that to the jury without the judge chastising the lawyer is unlikely. A judge would normally chastise a lawyer for that kind of almost trickery.
But thankfully, that same day, she entered the Beta Delta Pi wet t-shirt contest where she was completely hosed down from head to toe.
Objection. Why is this relevant?
Oh, I have a point, I promise.
Then make it.
Yes. Chutney, why is it that Tracy Marcinko's curls were ruined when she got hosed down?
Because they got wet?
Exactly.
Well, look, and subject to what I've already said, there is something interesting there, and that is the lawyer has used an anecdote, a personal anecdote, as a segue into framing a question to the witness. That's delicate stuff, but can be done. And if you are capable enough of being able to do that, it can be a really useful technique.
Because isn't it the first cardinal rule of perm maintenance that you're forbidden to wet your hair for at least 24 hours after getting a perm, at the risk of deactivating the ammonium thioglycolate?
Yes.
And wouldn't somebody who's had, say, 30 perms before in their life be well aware of this rule? And if, in fact, you weren't washing your hair, as I suspect you weren't because your curls are still intact, wouldn't you have heard the gunshot? And if, in fact, you had heard the gunshot, Brooke Wyndham wouldn't have had time to hide the gun before you got downstairs, which would mean that you would have had to have found Mrs. Wyndham with a gun in her hand to make your story plausible. Isn't that right?
She's my age. Did she tell you that? How would you feel if your father married someone who was your age?
You, however, had time to hide the gun, didn't you, Chutney? After you shot your father.
I didn't mean to shoot him. I thought it was you walking through the door.
Some unrealistic aspects to that and some realistic aspects to that. I mean, drama is drama. But what you do have is the lawyer using personal knowledge about something, possibly even personal experience or expertise about something, as a way to segue into a cross-examination question, while at the same time stating observations to the record that might be controversial. Very, very delicate stuff. Of course, this is drama, but the fact is that there is always a little bit of artistry and drama on the part of a trial lawyer. I guess another comment that occurs to me is that, again, I am right. This is cross-examination, as I suspected, and a non-lawyer might wonder: are lawyers in trial or lawyers in cross-examination really allowed to raise their voice a little bit? Are they allowed to be that direct with witnesses? And the answer is generally yes. The essence of cross-examination, the essence of the legal system, the trial system, relies on a cross-examining lawyer to attempt to shake, that's the term we use, attempt to shake the witness, and directness, loaded questions, leading questions, speeding up your questioning. Directness is a key tactic in that. And the premise is a witness who's telling the truth will have no trouble handling that. A witness who has been exaggerating or perhaps even lying will have problems facing that kind of approach and might even break down. A few good men, cross-examination, objections.
Colonel.
You snotty little bastard.
Your Honor, I'd like to ask for a recess. I'd like an answer to the question, Judge.
The court will wait for an answer.
If Lieutenant Kendrick gave an order that Santiago wasn't to be touched, then why did he have to be transferred? Colonel, Lieutenant Kendrick ordered the code red, didn't he? Because that's what you told Lieutenant Kendrick to do.
The defense lawyer here, Tom Cruise, is putting directly to a very powerful and key witness an alternate version of what the prosecution is trying to prove, and clearly an alternate version of what the witness is saying. And these are very direct alternate suggestions being made in a dramatic way at a fairly high tone of voice, and that is plausible. It's possible that in a courtroom, in a trial, that type of speed and drama and tone and directness would happen. And I think the first thing I want to comment on is the prosecution lawyer is making an objection. When a Canadian trial lawyer objects, it's very, very likely that a judge will intervene, hear the nature of the objection, perhaps even seek an explanation from the other lawyer in defense to the objection, and then make a ruling. This objection, I see no foundation for the objection.
Your Honor, you doctored the logbook. Damn it, Captain! You coerced the doctor.
Consider yourself in contempt.
Colonel Jessup, did you order the code red?
You don't have to answer that question.
I'll answer the question.
There it is, and fascinating. He says you doctored the books, and I can tell that Tom Cruise is about to essentially allege, as a cross-examination question, total misconduct, perhaps even a crime or a conspiracy on the part of the witness, and the judge barks out, "Consider yourself in contempt." I don't believe that. I don't think that's plausible that a trial judge in that context would have said to the defense lawyer, "Consider yourself in contempt." Asking tough questions like this, very dangerous if you don't get the answer you're looking for from the witness. But asking very tough questions like this is not contemptuous in my experience. Let's carry on.
You want answers?
I think I'm entitled.
You want answers?
I want the truth!
You can't handle the truth!
Here's what I will say about that. It is plausible that after a very effective cross-examination, what you've done is you've taken a witness out of his comfort zone, probably taken the witness out of a rehearsed line of questioning, and hopefully even gotten the witness into a line of questioning that he and the other lawyer had not contemplated. I want to be clear, the other lawyer, the witness's lawyer, would not have told him what to say, but they would have gone through, here's what I think is a line of questioning you may get asked about, and could you just make it clear for me that you do or do not know an answer? And in that regard, very effective cross-examination. The Dark Knight, cross-examination, sworn statements.
The Honorable Judge Friel presiding. I thought the DA just played golf with the mayor, things like that.
Tee-off's 1:30. More than enough time to put you away for life, Sally.
With Carmine Falcone and Arkham, someone must have stepped up to run the so-called family. Is that man in this courtroom today? Could you identify him for us, please?
You win, counselor.
Okay, well, the first thing that's happened there is that the district attorney has asked a witness whether a certain individual is in the courtroom today, and the witness nods yes. It is extremely unlikely that a witness would be allowed to nod without the judge or even the lawyers prompting that individual to use words. Why? Because there's a transcript. If there's ever an appeal, there has to be a transcript from the trial, and you have to use words. You have to say something to get, quote, on the record.
It was me.
I have a sworn statement from you that this man, Salvatore Moroni, is the new head of the Falcone crime family.
Moroni? He's a fall guy. I'm the brains of the organization.
Order.
Permission to treat the witness as hostile.
Granted.
Hostile? I see you hostile.
Yeah, interesting. A lot of things happening there. You've got a witness for the prosecution purporting to say that he's the bad guy. That is apparently in contradiction to a prior sworn statement, which is even more powerful than a written statement. But even if it was unsworn but written, he could be impeached. That's the word we use. The lawyer could purport to impeach the witness on the prior written statement. What's particularly interesting is it's his own witness. And you're not allowed to cross-examine your own witness. You're not allowed to ask controversial yes-no questions to your own witness unless the judge lets you. And on what basis? You would have to persuade a judge that your very own witness is hostile to you and hostile to your case. Now, I'm assuming this witness is a member of a crime family, probably the same crime family as the defendant, and therefore that probably would be sufficient grounds for the judge to say, yes, I am going to let you treat this witness as a hostile witness. So that's the type of recipe that a judge almost certainly would rely on to allow a lawyer to cross-examine his own witness. How to Get Away with Murder, closing arguments.
492,750. That's how many minutes Nathaniel Leahy, my client, spent in a cement box smaller than a parking space.
Wow, a quick comment already. The lawyer has extrapolated time into minutes. And I think she's talking about it being over 400,000 minutes. Wonderful technique, really, really cool. This is where the lawyer is being creative, but straight up factual. It's not even something that might have been in the evidence. How many hours or how many days someone might have been doing something would be in the evidence, but it's an example of how in closing argument you're using a technique of uncontroversial fact that everyone can understand, but as a way of making a point. And that is clearly she's making the point that whatever happened was for a very, very long time, probably in circumstances that would normally be intolerable for the members of the jury. We'll see.
Now, the prosecution claims that Nathaniel's time in solitary did not make him insane, even though a neutral, court-appointed doctor testified that it did. Not to mention numerous studies that prove that solitary confinement causes severe psychological disorders.
You can imagine that when the court has appointed an expert, a few things in that regard. The court normally is quite jealous of the reputation of that expert not being unnecessarily impugned by either of the lawyers. That the court would usually assume that that expert is treated with a great deal of respect. So let me assure you, if the court has appointed any kind of expert in a trial, you are going to be very, very hopeful as a trial lawyer, as an advocate, that expert comes up with an opinion that is consistent with your theory of the case. Now, how do you influence that? The answer is at the time that the court is making the appointment of the expert, you try to influence the terms and the assumptions that are being referred to the expert by the court.
The facts of the case are clear. Nathaniel Leahy went into solitary confinement for less than a year. And just days after he got out, he did something he'd never done before. He snapped, exploded. He lost his mind. Now, if you still don't think that that can happen, then I want you to put yourself in his shoes for 1 minute. Just a fraction of the time that he spent there. Here. $492,750 minutes. And all he heard was this.
The lawyer here is doing her own version of what we call demonstrative evidence, where she has had someone tape out a box on the carpet in the courtroom, ostensibly to act as a notional cell. And she is really slowing down her presentation. She's allowing a few seconds to pass between her words. And I can tell you, there are times in trial where a trial lawyer will do that. I'm going to give you an example right now. That was 3 seconds. And it seems like a long time. And if you even take 10 seconds of silence, which is not offensive to the trial process, probably won't even reach the transcript, and yet can really make a huge point to the finder of fact. That's an excellent technique being used by this lawyer. So thanks for watching this episode of Law for All. And if you have any questions, please feel free to email brentcooperlaw@gmail.com. And you can also find me at McLeod Law LLP. We'd be happy to get back to you.